Hello, everybody. Welcome to our webinar on this Thursday, afternoon here in the eastern part of Nebraska. I'm Ryan Evans with the Center for Agricultural Profitability at the University of Nebraska-Lincoln. And today is, of course, part of our regular webinar series. It's been ongoing for a few years now, happening on Thursdays at noon Central. And as always, please do find a schedule of upcoming webinars. There are quite a few up there now on our website at cap.unl.edu/webinars. Today, we'll be taking a look at recent decisions related to agriculture from the U.S. Supreme Court. Three in particular we'll be looking at today include cases related to California Proposition 12, which deals with limiting meat imports into California. We'll also look at a wetlands case dealing with what constitutes waters of the U.S., known as WOTUS. And we'll also look at a property tax forfeiture case, which could have important implications back here in Nebraska. As we go today, please do feel free to type in any questions you have in the Q&A panel, and we'll work to address those at the end of the webinar. And we're glad to have presenting for us again, Dave Aiken, who is a professor in the Department of Agricultural Economics here at UNL. He is also an extension agricultural and water law specialist and has been following these issues closely. So Dave, thanks for being here. I'll turn it over to you.
Great. Okay. Thank you, Ryan. Good afternoon, everyone. Yeah, it's a kind of an unusual year at the Supreme Court, that right at the end, when they finished up, got all their decisions written by the deadline, there were three cases that came out. I believe they all came out in May, and they all dealt with significant agricultural issues. And in all three of the cases, there was a high degree of agreement among the members of the court. And it's unusual to have three significant ag cases. One is, you don't get one every year. And so one would be the expectation, but getting three is kind of a lot. Okay, the first one will be the wetland case, the Sackett case, which dealt with waters of the United States. And that was a big victory for ag groups. I think they pretty much got what they wanted out of that decision. Second case is the Proposition 12 case, which California won. And so that was a loss for the pork producers and the Farm Bureau, and I think ag groups more generally. Then the last case is a property tax sale case, and that's kind of an interesting case, and that is one that turned out to be a victory for taxpayers. And so it'll be fun to take a quick look at all three of those cases. Our first case is the waters of the United States, or the waters of the U.S., or as Ryan mentioned, WOTUS for the acronym. And this is the WOTUS case, the wetlands case. And Section 404 of the Federal Clean Water Act, which is the Water Pollution Control Act that is really kind of drives all the water pollution control efforts in the United States. The Section 404 authorizes the EPA and the Army Corps of Engineers to administer the so-called dredge and fill permit program in waters of the United States. And traditionally, that was a law that the purpose of it was to avoid obstructing water courses, by building a bridge too low so that boats or ships couldn't get underneath it and stuff like that. And so it avoided threats to commercial navigation on the navigable waters. under the Clean Water Act, most of the 404 cases have that have ended up in court have been wetland cases. And these deal with where somebody, is filling wetland to try to create dry ground out of it so that they can put homes on it or commercial real estate or something like that. And not too many years back, Congress said, okay, as far as farmers and ranchers are concerned, for farmland and ranch land that's being used as farmland and ranch land is not being converted to another use, Natural Resource Conservation Service will do all the wetlands programming for under the Clean Water Act on those ag lands. And so, it's the Swamp Buster program that you're all familiar with, and that's governed by NRCS. That is not changed by this case. And so, as far as ag land being used for ag purposes, nothing is going to change today based on the Sackett decision. So that's that's good to understand. But if the land goes out of ag into commercial real estate or residential real estate or something like that, then the Corps of Engineers could come in on that. Okay, the Sacketts are an Idaho couple who own some land, basically 300 feet from a lake, 300 yards away from a lake. And they wanted to build a house. And so there was a wetland on their property, and they wanted to fill it, and raise the elevation so that they could build a house on that to live in. And so, they started that. Now, this wetland drained into a ditch, and the ditch drained into a creek, which was a non-navigable creek, small creek then. And the creek then drained into this lake, which was within the state of Idaho, so it's not interstate, it's intrastate. But the lake itself was navigable, and there's no disputing that the lake is navigable waters of the U.S. And so, and under the EPA regulations that were in effect, the wetlands that the Sacketts were filling were part of waters of the United States because they had a potential environmental impact on the lake. And so they needed a permit from the Corps of Engineers to do that. EPA sent them a letter, said, your filling of this wetland is illegal. You need to get the permit from the Corps of Engineers. If you don't, it's up to $40,000 a day per day of violation. And so, you need to stop what you're doing and apply for a permit from the Corps of Engineers. The Sackett said, this is our wetland, is not waters of the United States. And so they ended up in court. The lower federal courts said, no, under the EPA regulations, your wetlands are considered to be part of waters of the United States, and therefore you need to get the permit from the Corps of Engineers. And in my mind, remarkable ruling, the Supreme Court basically adopted the test, what I call this, and what lawyers call the Scalia test, from an earlier wetlands case, the Rapanos, I can't pronounce it very well. Anyway, the Rapanos case from about 10 years ago or so. And under the Scalia test, the wetlands needed to be physically adjacent to the navigable waters with a relatively permanent connection to those navigable waters. And so that, it had to be right there, not 300 yards away. 300 yards away is not adjacent unless you're, using a very, very broad scale. But, under the Scalia test, it needs to be right next to it. And that was not adopted by a majority in that earlier case. But now, both the majority and the majority basically adopted the Scalia test. So this means the wetlands, need to be right there, right next to the river, or the lake, if it's a navigable lake like it was in this case. And if it's further away, then it's not considered waters of the United States under this new decision. And so the whole question of isolated wetlands, they're out. And while all the justices agreed with all 9 justices agreed with the basic thrust of the Scalia test, 4 of them said, well, we'd go a little bit further, because sometimes these wetlands, they might be cut off, say, by, if you've got a flood control project in there, and so they build dikes that cut off the wetlands from the river, or something like that. In that type of situation, we would say that even though they're not physically connected because that artificial barrier was put in there, we would call that wetland waters of the United States, even though it doesn't meet the Scalia test because you've got that berm or that that big dirt structure that cuts off the river. But they all agreed with the basic test that here there's no question that the Sackett's wetland was not waters of the United States, and so they did not have to get the permit from the Corps of Engineers, and that was pretty remarkable. Okay, the EPA regulations that were basically overruled by the Supreme Court are based on what was called the Kennedy test for WOTUS. And the Kennedy test in the Rapanos case, there were 4 justices who voted with Justice Scalia, including Justice Scalia. He was one of the 4. Kennedy was the 5th vote for the majority in that case, and he said that if there's a significant nexus between the wetland and the navigable waters, then the wetlands would be considered waters of the United States. And under the Scalia test, there had to be, a water connection between the 2 of them, a physical water connection. But the Kennedy test is much broader. It says, no, it can be that, of course, but it could be broader than that. It could be an environmental test. It could be a habitat test. It could be a water quality test. If any of those things, if there's a water quality impact on if something happens to the wetland and that has a water quality impact on the stream, then that would be part of waters of the United States. He was the only justice who went with that. There were 4 other votes who were for even the more environmentally oriented approach than the Kennedy test. So his was kind of the one that was in the middle, and so that was why it was that was the decision. We have a new court now, and they all basically are going with the Scalia test. So that's important. Now, big legal issue that was not addressed in the Sackett case is tributaries to navigable water. And in Nebraska, the Missouri River clearly is navigable. Platte River, probably not. It's dry a good chunk of the year, that sort of stuff. So these, certainly in the traditional commercial navigation sense of, floating barges down the Mississippi River and the Missouri River and the Ohio River and stuff like that, to get goods to New Orleans, back in the 1800s. That's before we had the railroads, that type of thing. That's the traditional commercial navigability test. And the Missouri River would would satisfy that test. But all our other rivers in Nebraska, Platte, Blue, Elkhorn, Blue, Republican, would not, or at least very, very unlikely to. So they're not navigable themselves, but they are all sooner or later tributaries to the Missouri River. And so I think that's going to be an issue that will be addressed in the next big wetland case. And it probably will happen when EPA issues its revised Section 404 guidelines, which were the ones that were invalidated by Sackett. EPA has pledged that it will have revised 4041 regulations by September 1st. And so when EPA publishes those guidelines, for me, one of the big issues will be, will they talk about tributaries as being part of waters in the United States? And if so, how far back up will they go? I mean, they're not likely to go all the way back up to the headwaters, which is where it's probably diffused surface water before there's enough of it that it actually forms, maybe a little creek or a little drainway or something like that, and then before it gets bigger and bigger and bigger until it finally hits the navigable water. And that's important. It's important for the wetland issue. It's also important for broader water quality issues. Now, usually when we talk about waters in the U.S., we're talking about wetlands because those are all the cases that I'm before. But the Clean Water Act, which was adopted by Congress in 1972, so it goes way back. It says that before you dispose of wastes in the waters of the United States, you have to get a permit from EPA. And if there are if what you're doing falls under Section 404 instead of Section 402, which is the waste discharge section, but 404 is the dredge and fill section. Then you get your permits from the Corps of Engineers, but waste discharges from a municipality, from a industry, say from a meat packing plant, something like that. Before you can discharge into the river or stream or creek that make up waters of the United States, you have to get those EPA permits. Now, most states, 47 or 48 or 49 states administer the EPA program within their state, like Nebraska does, the Department of Environment and Energy does in Nebraska. And so you get the permit from your state agency rather than from EPA, but they are, EPA scrutinizes them, and signs off on them, all that stuff. So EPA is involved in the permitting process, but it's the permit comes from the state of Nebraska. And there's a chance that in some states where their definition of what states who has to get these waste discharge permits, if their definition of the waters basically that are protected through this waste discharge permit program, if the state's definition of the waters that are protected are based on the federal definition rather than on an independent state legal definition, then what counts as waters of the United States becomes very important. Using Nebraska as an example, if this meant that the only people that had to get waste discharge permits were people who discharge wastes into the Missouri River, everybody else, all the other industries, factories, municipalities, whatever, who were discharging wastes into all the other streams and rivers and creeks and so forth in Nebraska, all of a sudden they wouldn't have to have a permit anymore, at least in theory. Now, in Nebraska, our definition of what waters are regulated and subject to this waste discharge permit program is very, very broad. A little bit in jest, I say, you know, anything that's wet in Nebraska is protected. It's not, obviously, that's an overstatement, but it's broader than what's waters of the United States for sure. And so state law definition, that's, you know, is very broad. And so the waste discharge permit program in Nebraska is not going to change because of the Sackett case, because our program is based on state law, and we don't use federal definitions in the state law, at least in terms of defining the waters where these waste discharge permits are needed. And so that's not going to be an issue in Nebraska. It could be an issue in some other states. And so we'll just kind of have to wait and see how that comes up. And that could be an issue that is at least highlighted or mentioned in the EPA regulations that come out September 1st. So those regulations will be very important. And for some, you know, I think I saw something today or yesterday from a leader of an ag group in Nebraska saying that, well, you know, Sackett's not the last word. You know, EPA is going to do their regulations, and then we'll have to take them to court, and so it's going to be tied up again. And that's probably right. But the one thing that is really positive, I think, is that we have a big agreement within the Supreme Court on the wetlands issue, and that has been the issue that has kind of been driving this discussion. So I think we may not be at the end of the road, but I think we can certainly see the light at the end of the tunnel. And so that's so, you know, the file where I keep all my WOTUS related information is called WOTUS 14, because I set up that file folder in 2014. And, you know, here we are, not quite 10 years later. And, you know, but maybe we'll get close to the end. So I think that's something to keep your fingers crossed for. But the WOTUS, the Sackett opinion itself is, you know, should make agricultural groups very happy, and property groups in the United States very happy, because it's very, you know, it cuts out most wetlands in the United States as being waters of the United States, unless they come in as being adjacent to tributaries. But even if they come in as adjacent to tributaries, that's, you know, you know, in Nebraska, the ecologically important ones, at least as identified by Game and Parks or somebody like that, or the Department of Environment and Energy, you know, those are isolated wetlands in that they're not considered tributary or adjacent to a major river or stream. So, you know, good outcome for ag. Environmental groups will be disappointed, but it's it'll make a lot. I think it's more likely that it's going to be a lot easier for landowners to decide to be able to determine on their own whether they need a federal permit, you know, to fill wetlands on their property or not. Okay, next one. This is the Proposition 12 case, National Pork Producer versus Ross, who was the Secretary of Agriculture for the state of California. Proposition 12, adopted in 2018, regulates pork production in California. And so basically says no farrowing rates for pregnant sows. You know, they have to have at least 24 square feet of living space all the time. But also, they've said that, you know, if you're outside of California and you want to sell your hogs or your meat products, your pork meat products into California, the hogs have to have meet the same animal welfare requirements in terms of spacing and so forth that producers do in California. This is, and they would say we did this so that out-of-state producers with cheaper production costs because they could use fair rates, they could flood California with pork, and our California producers with higher costs would be would go out of business, and we want them to stay in business. So if you want to sell your pork in California, you have to meet the California requirements. It's kind of like the ethanol. If you want to meet the low carbon requirement, excuse me, if you want, it is like ethanol. You want to sell your low carbon ethanol in California, then you've got to meet our low ethanol standards. This is kind of the same type of deal. Okay, pork producers and Farm Bureau challenged this, and finally in 2023 we had a decision, and they said that California is trying to regulate pork production outside of California, and that's interstate commerce, and only Congress can do that, and that California can't do this without permission from Congress, and this is under the Interstate Commerce Clause of the United States Constitution. Now, the Supreme Court said you're wrong. It says because we can think of a wide variety of laws that states pass all the time that under your statement of the case would be illegal. For example, if the state lowers its tax rates to try to encourage people and businesses from outside of that state to come into the state, which sounds pretty familiar to us in Nebraska. We hear this almost every legislative session, that we want to keep people in who are here, and we'd want new people to come in, and so we're going to lower our tax rates to be more competitive, our state tax rates. The Supreme Court said that kind of a law would be unconstitutional under the Commerce Clause, under your interpretation of what the Commerce Clause means. And so they said that, so the California Proposition 12 is not unconstitutional under the Commerce Clause. It doesn't violate the Commerce Clause. Now, there was a second challenge, and they said, and the pork producers and Farm Bureau said, okay, the benefits from the Proposition 12 are far less than the costs that they impose on California consumers of pork products, as well as out-of-state pork producers, who would like to sell pork into the California market. And so, because there's such a great disparity between the benefits and the costs, that it should be unconstitutional. And the court split three ways. I mean, most of them said no, that doesn't work for you. But it was, it's very complicated, and they all had lots of reasons about why their way was best, and so forth. But there was not any agreement on that. But there was agreement that that Proposition 12 on its face did not violate the federal Constitution. Now, I personally expect this to be a significant issue in the debate over the Farm Bill. I'm calling it the 2023 Farm Bill, but it's probably going to be the 2024 Farm Bill before we actually get there. And the best chance that ag groups have in doing something about Proposition 12, if that's something that they feel is a really high priority, their best chance is going to be, I think, through the Farm Bill. And so we will just kind of have to wait and see how that all plays out. And I don't follow the Farm Bill super closely, so I can't. I don't have any predictions. Other than I think that we will see that conversation as part of the larger Farm Bill conversation as the next farm program is authorized. Okay, the last one, excuse me, is this tax case. And 94-year-old lady had, having financial problems, had not paid her property taxes. They had become delinquent, and which authorized the county to sell her condo at auction to pay her unpaid property taxes. And they did that, and it was $15,000 to settle all of her property tax bill. But the condo sold for $40,000, and so there was $25,000 left over. And the Minnesota law, this tax sale law that they had in Minnesota, allowed the county to keep all of the money that it recovered from the sale. And so the taxpayer sued and said, this is confiscation. The government is taking my property, my $25,000, and keeping it without, in essence, paying me for it. And, the way they could pay her for it would be to give the $25,000 to her instead of keeping it. And so they said this violates the property clause, the takings clause of the U.S. Constitution. And so I should, excuse me, I should get the $25,000. The county shouldn't be able to keep it. And again, we had a unanimous Supreme Court. They agreed with the taxpayer and said that the county had to get, they couldn't keep the $25,000, and so they had to, and that they had to give it to her. Excuse me. Okay, most states have provisions like this for when people don't pay their property taxes. That after a certain period of time's elapsed, they can go ahead, they can sell the property for the unpaid taxes. And we've got a law like that in Nebraska, and most states have that. And the reason for that is, so that the counties can receive the tax revenue, property tax revenue that they collect on behalf of not only the county, but school districts, single purpose districts. In Nebraska, it'd be like natural resource districts, community colleges, all that. County doesn't just collect property taxes for themselves; they collect it for all of the local government units within the county. It works a little bit differently in Nebraska. Basically, if the taxes have become delinquent, then the county can file a tax lien against the property. And once the tax lien is filed, if some third party, and I'll call them investors because a lot of times they are companies who are in the business of doing this tax lien thing, if they pay the taxes and then pay the back taxes, excuse me, and the fees and everything else, and then they continue to pay the property taxes for the next 3 years, and the true owner of the property does not pay the taxes over the next 3 years, then the third party, the investor, can receive title of the property, and then they can go ahead and sell it, and then keep everything that they get from the sale of the property. And this has been challenged in Nebraska, but the Nebraska Supreme Court says, look, the taxpayer has plenty of chances to pay their taxes, and if they can't, and they have so many chances in this process, in this entire process, to get those taxes paid. And if they don't do it, it's kind of on them. And so we can't say that this is unconstitutional. Well, the Supreme Court basically said that it is unconstitutional, even though there are some legal differences. Certainly, the spirit of the law is of the Tyler case is that the taxpayer should get after the taxes have been taken care of, then the property owner should get anything that's left over. Okay, so this year, the legislature in LB 727, which was a big revenue bill, one of the big revenue bills that was adopted this year. The current process that I just described was changed, and they basically, long story short, they basically require the investor or the third party who came in and paid the back taxes, paid 3 years taxes, and then got the property to pay anything above what it cost them to take care of all that, and so that most of the profits, if you want to think of them that way, from selling the property would have to go back to the original property owner rather than being able to keep them. The law also requires more notice from the county to the taxpayer to try to get the taxpayer to take care of it, so that it doesn't get into this tax lien process. And one of the issues that was raised, when this bill was proposed to the legislature, was that the reason that Nebraska had the law that let the entity who paid the back taxes and then paid the next 3 years taxes was to make sure that county government didn't have to wait on all these unpaid taxes, that they could get the unpaid taxes repaid more quickly than the taxpayer, than the delinquent taxpayers might be able to do. And so we will have to see if changing the program, now the large financial incentive for these investors or these companies to do this tax lien sale, be involved with that in Nebraska, the financial incentive is much less than it was before. And it'll be interesting to see if they continue to do it or if they say, okay, we're finished. If counties have problems with delinquent taxes and so forth. So we'll see how that plays out. We'll see how that plays out in Nebraska. But we won't know until a few years down the road at least. Okay, I think that is I'll stop there for now, and it looks like we've got 20 minutes or so for questions, and so I will see if I can stop sharing my screen and turn it back to Ryan.
All right, thanks, Dave. And yeah, we want to remind you, if you do have questions, please type those into the Q&A panel at the bottom of your screen here, and we'll put those to Dave. And Dave, one that came in during the discussion of, I believe it was during the Prop 12 discussion, attendee asked if you think that the precedent from the California Prop 12 decision can be applied to other sectors of the ag industry, such as ethanol.
Yeah, yes, I do. I think it's a pretty close parallel. So, I think that's why we have the interest in Nebraska among some of our ethanol companies in the carbon dioxide pipelines, so that they have some way to dispose of carbon dioxide that they capture in their process to make their ethanol a low carbon fuel, meeting the California requirements in that. I think if somebody attacked the low carbon fuel program in California, I think that they would be, I think they would have the same challenges that the livestock groups have had in challenging Proposition 12. But it'd be a fun lawsuit to watch.
Absolutely. And so just for clarification, the question is, if filling wetlands on my land, if I'm filling wetlands on my land, does that court decision, the Sackett decision, affect then the process that I need to follow or have been following when I've done it in the past?
Okay. if your land is agricultural land, cropland, or, pasture, whatever, you would need to check with NRCS to see whether what you are proposing to do would put you in trouble with Swamp Buster. And, and if they said, yes, that would put you in trouble with Swamp Buster, then, you could sue them, or else you could decide, well, is it worth it for me to lose access to those farm programs, or, to fill however many acres it is I want to fill of wetlands, or do I just live with it? But it doesn't change anything in the ag land as ag land, wetland scenario. It's still Swamp Buster and NRCS is where you go for your answer. Now, if you're converting, ag land to residential or commercial or industrial use, something like that, I would still check with the Corps of Engineers, and they would likely say, if I had to guess, they would say, we won't know until we see what the new EPA regulations are. And until those new EPA regulations have been issued, they've thrown the old regulations out. We don't have new ones yet. And so, we're going to kind of have to wait and see on that. They might go back, to an older set of regulations, but those older regulations would be, slight modifications of the current EPA regulations that were kicked out by the Sackett case. And so I think you're not going to see a big change in terms of the Corps' regulatory program until there is some clarification on the tributary issue, and we won't see that until we see the new forthcoming regs from EPA.
Great. Thanks, Dave. And a reminder to people, if you do have a question that comes to mind, type that into the Q&A panel in your Zoom window, likely at the bottom of your screen, and we'll get that to Dave. And you mentioned this during your presentation, Dave, but if you can expand on it perhaps a little bit right now, if a hog producer in Nebraska is wanting to sell hogs to California, do they need to follow to the T then the standards set forth in the Prop 12 law?
Yes, they do. I think their Department of Ag has regulations that says if you're an outside of California hog producer and you want to import hogs or pork products into California, here are the production requirements that you have to meet. And it's basically the housing regulations that have to be met. And so, and the Supreme Court was, unanimous in saying that, they're going to have to do that. And I think that, again, if we don't see something in Congress, well, we may see something in Congress that modifies this with the Farm Bill, that if that happened, California would challenge it. And so there would be a year or two before it would reach the U.S. Supreme Court, maybe longer than that before it got to the Supreme Court. And so, there would still be a waiting game. So I think for the foreseeable future, if you want to sell into the California market, you're going to have to meet the requirements. And I believe Maine also has similar requirements, obviously a much smaller market than California, but so I think there are some other states who have kind of looked at this as well. But of course, California is the big one.
Great. Okay. Thanks, Dave. Great stuff. Right now, I don't see any more questions. Oh, one just came in as soon as I say that. So thank you for that question. So I'll just read this to you here, Dave. In NPPC, the court ruled that California did not violate the Dormant Commerce Clause. How would this impact what Massachusetts, in quotes or in parentheses, it says, I think, is doing, where they are trying to prohibit the transport of livestock through their state unless they meet certain requirements? Do you have any perspective on that?
Yes. This is not an issue that I've researched, and I'm certainly not familiar with all the Commerce Clause cases and that. But if any state is saying, you can't ship your hogs through Nebraska for processing in Iowa unless the hogs that you ship through Nebraska meet Nebraska hog production animal welfare criteria. I think that case would lose. I think Nebraska would lose that case in the Supreme Court because they're not being consumed in Nebraska. That seems like a very obvious barrier to interstate commerce. And so I think that there, but again, I'm not a Commerce Clause expert by any stretch. But I would say that law, a law like that, would probably be, you go to the district court would probably throw it out as being unconstitutional. So it would be, I think that one would definitely go the other way.
Good. Well, thanks, Dave. And thanks for that question. Another one that just came in, another good question, actually, Dave, that we were just talking about before we turned the webinar on here earlier this afternoon. Says, yesterday I saw news about foreign countries buying U.S. ag land. So with the regulations California has for pork and ethanol, is there a slight correlation with that lawsuit and what is being discussed in Congress with the foreign countries?
Okay, I'm going to have to modify the question a little bit so that I can answer it. I do think that that clearly the alien land ownership issue has been on the radar, at least in the Midwest, for the last year or so. And I think Congress has never done anything beyond requiring foreign entities that purchase land in the United States fill out an information form with USDA. And I think a lot of people and groups feel that there should be a national law to this, that there are national security concerns and other concerns, a variety of concerns, but certainly national security concerns would be one that would sort of ring my bell, so to speak. I think that is going to end up being an issue again in the 2023 Farm Bill, and there's been some action, I think, in the Senate where they passed something and they basically said, if you're from this list of 4 countries, Russia, China, and North Korea, and Iran, or somebody, I forget the 4th one, that you can't buy land in the United States. I think there's a lot more political momentum for that in Washington, D.C., and so I think that's something that will come to the fore. And I've been asked by Dr. Van Tassel if I could pull some information together on this on the legal side, and I have said yes, let's do it. And so keep watching your emails from Ryan, and we may get something scheduled here before too long.
Great. Thanks, Dave. Another one here, wondering if Prop 12 in any way would affect cattle producers in Nebraska. And then if you have any take on whether or not California residents might work to repeal Prop 12 when pork prices go up?
Okay, it's been a long time since I've looked at Proposition 12. My recollection was that the housing requirements were pork and poultry, and so bacon and eggs, so to speak. And I don't think they had anything there with regards to beef cattle or dairy, and so never say never, but I don't think that's so I don't think there's anything. There's nothing in there now, and I don't think there's anything on the horizon. In terms of repeal of Proposition 12, I haven't seen anything about anything that goes into the differential pork prices in California versus the rest of the country. I do remember that there was a lot of when the restrictions took effect on the poultry side with eggs, shell eggs. I think there was a lot of conversation about that and kind of up to that, but then after that happened, I don't have a sharp recollection that there was a big difference in price or not. I mean, I do a scan on different, ag and other publications and stuff, and it just kind of disappeared after that. And so maybe somebody else has better information on that than I do. But to me, it seems like it dropped off the radar screen, and so it must not have been whatever price shock there was must not have lasted too long, and so that's the best answer that I can give. But if any of my colleagues are on the have better information, or anybody in the audience has better information, type it into the chat box or something, and Ryan will get it shared. Oh dear.
I am muted. Sorry about that. Thanks, Dave. Thanks everybody for attending today. I don't see any more questions right now. So we're going to go ahead and wrap it up, I think, unless something comes in here while I'm making these closing remarks. But I want to thank everybody for attending and for your questions. As you exit, you should be presented with a brief survey where you can let us know how today went and any ideas you have for things that you would like to see the Center for Ag Profitability cover in upcoming webinars. And that survey, again, should pop up as you exit Zoom. You can look for a recording of this webinar that should be posted in an hour or two in the archive section of our site at cap.unl.edu. Just click on the webinar page and you'll find that archive. We'll be back next week with a look at the brand new custom livestock rates report here in Nebraska and how that information can be used by custom operators and producers paying for those services across the state. So do join us then. And until then, I hope you have a nice rest of the Thursday. And Dave, thank you very much again for the great presentation today.
Thank you, Ryan.
All right, take care, everybody.